Hello, everybody. My name is Juan Carlos Brando, and thank you so much for having us today in this show with one of the attorneys in the law firm of Margaret W. Wong, who has been working on this field for over 45 years and has a huge office in the city of Cleveland, but also 9 offices in the United States. So please join us. Feel free to ask your questions, and if you have any concerns or more doubts that you would like to clarify, just give us a call. The phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to get in touch with the attorneys in the law firm of Margaret W. Wong. We are transmitting through Facebook, YouTube, and also another pages that you can find online. So thank you so much for joining us today. Today we're going to talk to one of the experts in the law firm. I would say one of the most brilliant attorneys that I had the chance to talk, which is the attorney Francis Fonseng. He's very, very accurate in his answers, but also he knows a lot about work-based visas. So if you have any questions regarding to work-based visas, just send them here and he will answer your questions. Good afternoon, Attorney Francis. Thank you so much for having us today. How are you doing?
I'm doing well, thanks. Good afternoon.
Thank you so much, Attorney. And right now we're in September. We're starting September 2022 this year. And what is new right now regarding to some work-based visas in the United States?
Well, there haven't really been that many changes with work-based visas. One of the biggest changes earlier this year was the new law regarding EB-5, which is the investment process for the green card, where you invest a lot of money, hire U.S. workers, and get a green card through that process. The new law increased the minimum investment from $800,000 US dollars up to $1,050,000, depending on whether the location of the investment qualifies as a targeted employment area or high unemployment area. So that's one of the big changes this year in employment-based immigration.
Okay, thank you so much, Attorney Francis. And for these cases of the people that are entering through the border, this is not a work-based question, but this is a asylum or arriving aliens or immigrants question. Are they able to file for a work permit once they have been paroled in the United States?
Okay, so when somebody arrives at the border and declares that they have a fear of returning to their country, they go through what's called a credible fear interview. And if they pass that interview, and they are paroled into the United States, that means they're permitted to enter to pursue their asylum application, and they get an I-94 card, then they're allowed to apply for a work permit based on that parole. Now, the parole is usually 1 year. It might be 2 years. They can apply for that work permit based on that parole time. If you want to renew the work permit, then you have to extend the parole.
Okay, so if this person, because that's what we hear, that they are entering through the border, they are surrendering at the checkpoint, but they are not going through any interview, but they are just walking through. They are getting checked. Maybe they take the fingerprints and then they just keep walking. Are they in the same situation or they have to wait for the NTA?
Okay, so parole is up to immigration at the border, whether they decide to parole or not. It's discretionary. Now, generally, if you are allowed into the United States, you should be paroled, because how else legally can you come in? Immigration just doesn't let people just come into the United States. There's a legal mechanism. The parole document allows you to enter. And in general, they will NTA, which means put you into removal proceedings, because that's how you pursue your asylum application. Now, there are some people over the years who are kind of in a gray area where you're allowed into the United States, you're given a notice to appear, an NTA, but that NTA is not filed with the court, which would start the deportation case. And so that causes an issue. Well, you have the NTA, but you don't have a court case pending yet. What do you do? Now, because there's that 1 year rule for asylum, you're supposed to pursue asylum within 1 year of coming to the United States. I would recommend that you file that asylum application within 1 year of your entry, even if the NTA has been filed with the court. You can file it with the USCIS because the court doesn't have jurisdiction yet. Now, eventually that might change once the NTA is filed with the court, but at least this will preserve your argument that I did try to pursue my asylum on time.
Okay, thank you so much, Attorney Francis, for this answer to this question. And if you have any other question regarding to this, you can just call. The phone number is 216-279-3984, 216-279-3984. This person is asking, hi, I am Venezuelan. I have an OPT work permit, but filed for TPS and it was granted. If I filed for an EAD based on my TPS and start working on something different to my prior permit, would it be a problem? Thank you.
Okay, so this comes up a lot. You have your OPT, which is based on your F1 student status. Your TPS EAD will be based on the TPS. Now, you're allowed to maintain both at the same time, but if you use the TPS EAD to work for an employer that is not eligible for your OPT is supposed to be in a job that is related to your field of study, your major. So if you use the TPS EAD to work in a job that is not related to your major, that would violate your OPT, and so that would violate your F1 status. Now, you're still lawfully in the United States because you have the valid TPS, but the F1 status would be canceled. If you want to maintain the F1 status, then you have to make sure you maintain that OPT validity.
So, attorney, and I'm just asking this question: would this affect, and eventually, in the future, if this person is going to ask for or apply for a green card, would this person be affected if they change? They violate the OPT work permit and start working with the TPS work permit?
As long as there's no gap, then it should not affect the green card in the future. So, for example, you have the valid OPT. While the OPT is still valid, you successfully apply for the TPS, and then you don't work illegally. You maintain the TPS, you stop working for the OPT, and then you're maintaining legal status this whole time, you should be okay.
Okay, perfect. Thank you so much, Attorney Francis. So if you have any other question, please give us a call. The phone number is 216-279-3984, 216-279-3984. Don't forget that the attorney, Margaret W. Wong, has offices in 9 cities of the United States, in Atlanta, Chicago, Cleveland, Columbus, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984 is the phone number that you can call today. They have over 45 years of experience working on the immigration field and have helped thousands and thousands of families every single year. So we have a next question. Hi, I am a civil engineer. I live in Colombia. What would be the process for me to go to the US and work legally? I read some article that says that the US is requiring professionals in my area.
Okay. So in general, the most common way to come to the United States is to find an employer who's willing to petition for you, okay, with a job offer, willing to hire you. When we talk about immigration, there are temporary visas and permanent. So temporary is as a visitor, a student, a temporary work visa. Whereas on the permanent side, you've got the green cards. It could be family sponsored, could be employer sponsored, could be self-sponsored. So first you have to decide, how am I going to come to the United States? Is it going to be a temporary visa, or I'm going to try to come on the green card? On the temporary visa side, if you want to come to work, then in general, you have to find an employer who's willing to hire you and file a work visa petition. Could be H-1B, could be O-1. H-1B is for professionals, for jobs that require at least a bachelor's degree, for example, civil engineers. But the H-1B goes through a lottery process because there are more applicants than slots. There are a limited number of slots each year. And so the lottery is held every March. So if you do find an employer willing to support the H-1B, then that lottery selection process happens in March. That's when you want to apply online. O1, on the other hand, is for people with extraordinary ability. That means, have you won any awards? Have you had your work published in journals? Have you been mentioned in newspaper articles? Have you written any articles? Have you been a member of any professional organizations? Okay. If you can show that you have international and national renown, then you might qualify for an O1, but you still have to have an employer willing to file the petition for you. You just don't have to go through a lottery process. On the green card side, let's say you don't get selected in the H-1B. You don't meet the qualifications for the O1 because of the extraordinary ability, but the employer is still willing to bring you to the United States. Well, the employer can file directly to sponsor you for the green card through a process called labor certification, or PERM, P-E-R-M. That's a 1.5 year to 2 year process where the employer goes through an advertising process where the job is posted in the newspaper and other media to see if qualified U.S. workers are available for the job. If a qualified U.S. worker is not found, then the sponsorship can continue and you go through all the paperwork. Eventually, you'll be scheduled for an interview at the U.S. Embassy in Colombia to get your permanent immigrant visa. When you arrive in the United States, you are automatically a permanent resident. The green card is mailed to you. Okay. If you're interested in that process, then you can contact us, but you do have to find a U.S. employer who's willing to offer you a job to go through this process. There's also self-sponsorship for the green card. Similar to the O1, there's the EB1A for extraordinary ability individuals. You don't need a job offer. You can come to the United States to pursue your own plan in your field of expertise, but you still have to meet that high criteria. Have you won any awards? Have you been mentioned in the newspaper or media? All of those criteria. So you can get in touch with us to ask more details about these if you're interested.
Okay, thank you so much, Attorney Francis, for this answer. And this is very important to for you to know that all of the processes of, or all of the probabilities that you could try in order to come to the United States. So if you have any other question, please don't forget to call 216-279-3984, 216-279-3984. We have another question, is interesting. My name is Nicole, and I am a client. I followed up as Ms. Wong advised with a case worker regarding my petition, which was filed August 2017, and they are saying that the current date is 2015, which I honestly thought was 2016. After looking at the visa bulletin, and they said that they would not be able to do anything for another 1 year or two. She mentioned about getting a Congress representative to write a letter. My question is, what are acceptable grounds to do so? I also asked because on a short visit to the UK last year, my mom had some sudden medical emergencies, which has resulted in her grounded until treatment is finished. I'm looking to see if there is any avenues to explore to either speed up the process or get in. Thank you for all your support.
Okay. Now this question didn't say whether this is an employment-based case or a family-based case. In general, there are a limited number of green cards that can be approved each year for each country, for each green card category, okay? And it's called a quota system. And if you look at the visa bulletin, which is published by the State Department every month, you can see in each category who can apply for the green card and that month, because you have to be current. When you file your case, you get what's called a priority date, the date that you are placed in line for a green card number. The visa bulletin lists all the priority dates who are eligible to file for the green card and get their green card approved that month. Some categories, there's a much longer wait. For example, brothers and sisters of US citizens, that wait can be 12, 14 years waiting in line. Whereas if you're married to a permanent resident or your parent is a permanent resident, there might be no wait, okay? And so this person, if the priority date is in 2017, that means she started the case in 2017, but the visa bulletin only says 2015 is being processed now. That means she still has to wait in line before she can finish her case, okay? And so first we have to figure out what category is she in? And number two, what country is she from? Because certain countries have a longer wait than others. And then we can figure out, okay, are we eligible to finish the case this month, or do we have to wait longer? Now, can we speed this up? Unfortunately, no. Even if you have the most extreme humanitarian situation, you can't jump the line in this quota system. You are set to that priority date. Now, it's possible that you have another avenue to get a green card another way, but if this is a family-based petition or employment-based petition, and you're subject to this quota, then you have to wait in line just like everybody else. Doesn't matter if you got congressional help or there's an emergency. Unfortunately, you can't get the green card more quickly.
Thank you so much, Attorney Francis. And this is a question that people ask sometimes, and there is no way that you can speed up the line in these visa bulletin cases. So thank you so much, Attorney Francis, for the answer. Don't forget that the phone number is 216-279-3984, 216-279-3984. The next question is, I got both my tourist and my student visas denied. I am single, have no kids. I am from Central America. Just wanted to go either to do tourism or study English for the TOEFL, but I can unless I apply again. Any advice for people like me who are single and have no children? How do you prove you need to go back to your country?
Okay, so it looks like this person is in his home country in Central America, trying to apply for the visitor visa or the student visa at the US Embassy and got denied both times. Now, when you apply for the tourist visa or student visa, those are called non-immigrant visas or temporary visas. You have to show that you don't have immigrant intention, that you're actually planning to go back to your country after your visit or your studies are completed. Now, how do you show that you don't have immigrant intention? Well, do you still have a home in your country to return to? Do you have family in your country to return to? Do you still have a job in your country to return to? Do you have bank accounts? Do you have properties? Something that ties you to that home country to show I have some place to return to after I'm done. Now, if you don't have any of those things, then the US consulate might think, well, you might be coming to the United States and overstay your visa. Now, that's not very fair, but the power is completely in the US Embassy's hands. So sometimes the officer at the embassy will tell you, this is what the problem was in your case. You have to do this, this, and this to fix it. If they don't tell you anything, then I would suggest maybe getting a job so that you have a history of employment, and then you can take maybe a leave of absence from that job. And you can show when you go to the interview, I have this job, they're letting me take a leave of absence to go on this visit, to take this class, okay? You can also explain how taking that class could help you in your future job in your home country. All right. And another thing is sufficient finances. You have to show that you have enough money to support yourself in the United States during your visit or to pay for the school. And so if you have those funds, that'll help you also.
Okay. Yeah, that makes sense. And thank you so much for this clarification to this question. The phone number is 216-279-3984, 216-279-3984. Would it help if this person gets married?
It's possible, because then if you are coming to the United States, your spouse is going to stay in your home country, then that shows a tie to your home country. But if it's from a country where a lot of people are trying to come to the United States, everybody is getting their visas denied. It's not targeting you specifically, so it might not really help you if everybody else, if you're lining up to go to your interview, everybody's denied. Your turn. I mean, there's not much you can do sometimes. It's not very fair.
Okay. Yeah, well, let's just get ready for any possibilities that you could have. And if you need more information, just call the attorneys in the office of Margaret W. Wong. The phone number is 216-279-3984, 216-279-3984. I have lived in the United States for 20 years, have 3 kids, never left. One of my kids has special needs. Could this help me get a green card? I am from Mexico.
Okay. So this person didn't say how he or she came to the United States, how she entered, whether it was legally or illegally.
It was without inspection. Yeah.
Okay. If the person came without inspection, even if you have a U.S. citizen child who's over the age of 21, who could file a petition for you for the green card, even if that petition is approved, you wouldn't be able to get a green card through that petition because you didn't enter legally. Now, if you leave the United States to apply for the visa at the U.S. Embassy in Juarez in Mexico, you would need a waiver of your legal time, those 20 years in the United States. But to qualify for a waiver, you need a spouse or a parent who's a U.S. citizen or green card holder. So if you don't have a spouse or a parent who's a U.S. citizen or green card holder, you can't get a waiver of that 20 years of illegal time or that illegal entry. Okay, so the kids are 9, 8, and 3 years old. They're very young. It's going to be a long time before one of them can petition for you. So there's no direct way of getting the green card. Now, if you are in removal proceedings, if immigration starts a deportation case against you, and you've been in the United States for at least 10 years, and you don't have a serious criminal record in those 10 years, and you have a parent, spouse, or child who's a U.S. citizen or green card holder, then you might qualify for what's called cancellation of removal or 10-year cancellation. Now, if one of your children has special needs, that might make your case a lot stronger for the judge to grant your green card, because that child could have extreme and unusual hardship. Life would be very tough for that child if you had to leave the United States. And the problem with 10-year cancellation is you can only apply in front of the immigration judge. You can't just walk into court and say, I want to apply for cancellation of removal. You can't submit the application to regular immigration service. Immigration has to start a deportation case against you. So I don't know what kind of a stage you are right now, if you ever had a deportation case in the past, if you have any kind of other immigration case pending. Sometimes if you file paperwork with immigration and you were denied, they will start a deportation case against you, which means that you can pursue this cancellation case with the judge. Otherwise, there isn't much you can do unless the judge starts that case against you. All right.
Okay, thank you so much, Attorney Francis. Well, don't forget that the Attorney Francis works in the law firm of Margaret W. Wong, who has been working for 45 years in this field. And the Attorney Francis is one of the experts in some of the areas most important for immigration. So if you want to call, the phone number is 216-279-3984, 216-279-3984, and 9 offices in the United States. The headquarters are in the city of Cleveland, and all of the other offices are absolutely functional. So you can go to Atlanta, Nashville, Memphis, Cleveland, Columbus, Chicago, New York, or Minneapolis, or Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. This next question here is, I need to do my citizenship, but I can't find the date when I became a resident. How can I find that? Thank you.
Well, the easiest way to find that is to look at your actual green card. On the green card, it'll have your name, your date of birth, your country of birth, and will also have resident, since, and the date will be right there. So you will need the green card to apply for your citizenship. So look at the green card itself. If you've lost your green card, then you would need to file the form I-90 to replace it.
Okay, thank you so much, Attorney Francis. And this person adds, is there another certificate that I need to find?
No, when you apply for U.S. citizenship, usually you would just need to have your green card, your state ID, and your passport. And that's all you need when you submit your application. Now, if you can apply based on being a resident for 5 years, or you can apply based on being a resident for 3 years if you are married to a U.S. citizen and you've been living with your U.S. citizen spouse for those 3 years. If you use the 3-year rule, you also have to submit documents to immigration showing you've been together with your spouse for those 3 years.
Okay, thank you so much, Attorney Francis. And don't forget, for this person, the phone number is 216-279-3984, 216-279-3984. It looks like we have a couple minutes more. So let's do the last question for today. I would like to hire you to get my mom legal here and file a motion to reopen her case. I will call you tomorrow to make an appointment and start the process after I get a quote on how much it will be. It looks like this person was deported, or because it has a motion to reopen. Is it possible to reopen a case when a person has been actually deported?
Okay, so there's a difference between being deported, which means immigration has taken you outside the country and you are now outside of the United States, or ordered deported, which means you had to go to immigration court, the judge denied your case, and the judge ordered you to be deported. Now, if you're physically in the United States and you have a deportation order, then you can pursue a motion to reopen that deportation case to get back in front of the judge. If you are physically outside the United States, it makes it very much tougher to reopen that case because you're no longer here to pursue your case. If you're physically here, there are different ways you can reopen your case. It depends on if you're eligible for the green card. Has something changed in your home country or in your personal life since you were ordered deported? Was there a problem with your previous deportation case? Did the judge make a mistake? Did something happen with your case that shouldn't have happened? So bring all of your paperwork and to see us, and then we can discuss to see what's the best way to reopen that deportation case.
Okay. And would the Nis Chavez case work in this case?
So Nis Chavez is a Supreme Court case last year where the Supreme Court said that a lot of the deportation cases should never have started because the Immigration Service, when they issued the notice to appear, the NTA, to start the deportation case, didn't have the proper information on the form. So those cases were invalid. Now, since then, the immigration courts, the Board of Immigration Appeals, a lot of circuit federal courts, they've come out with a lot of decisions and making it more difficult to reopen cases or to terminate cases based on the Chavez case. But it's one of the options we can pursue. So we just have to look at each case is different. It's not like we can reopen every single case. We just have to pick the best strategy for your particular case.
Okay, thank you so much, Attorney Francis. And this is kind of a funny question, but I have it. It's a personal question because I saw someone sent me a video yesterday of someone just giving information, and I just want to verify that this is true or false. So this person is saying that President Biden is working on kind of opening the aerial borders to people from who come flying from Venezuela or uh, that are Venezuelan people, and that they can do the same process in the airport as at the border with Mexico, so that they don't have to come and struggle in all the countries and cross all the countries in Central America. And once they make it here on a flight, then they are gonna do the process, like parole them in, and then they can come into the United States. Is this true or false?
So I have not heard anything about this kind of aerial program. The problem is that to get onto an airplane, the airline won't let you get on unless you have a travel document. That means either a visa and your passport, a travel permission paper, a parole document, some sort of travel permission to get you on the airplane. Okay. Now, at the border, you can just get to the border and then talk to immigration to try to enter the United States and explain that you want to apply for asylum, but that doesn't work at the airport because the airlines control who gets on the airplane. So unless the person actually has permission to travel to the United States, I doubt that this program will actually happen.
Yeah, this was just someone, a random person on the social media doing this video. This person sent it to me, and I said, well, that looks really, really fake, and it looks too good to be true. So I just wanted to make sure, asking an attorney who, actually, if you don't have a visa, a tourist visa, they won't let you get on the plane in your country. So it doesn't make a lot of sense to me that this could be happening. And even this person doesn't say Joe Biden, but this person says John Biden. So it's a different person. So thank you so much, Attorney Francis, for all your answers today. I hope you have a good lunch, and see you next time.
All right. I'll see you later, Bucklers. Thank you.
Thank you so much. And for everybody who has joined us today, don't forget that you can call the phone number 216-279-3984, 216-279-3984. Over 12 or 14 attorneys are working in the law firm helping with your immigration case, and over 60 people are working your immigration case in the headquarters office and the other 9 offices in the United States. So don't forget to call. The phone number is 216-279-3984, 216-279-3984.